Ani Bojo. Good morning. My name is Diane Corbier in English. My spirit name is Wajgesh Nadokwe, Dijnakazin, Makwa Dodem, Chiging Donjaba. I said that my name is Spirit of the Deer Woman. I'm of the Bear Clan and I'm from Chiging First Nation. And it's my pleasure as bencher of the Law Society to welcome you to this Indigenous Justice session, the first program for Ontario's 4th annual Access to Justice Week. I wish to start by recognizing that we are here together in Toronto, which is a Mohawk word that means, and you can correct me later, Doctor, where there are trees standing in the water. I'd like to acknowledge that we are meeting on the traditional territory of the Mississaugas of the Credit First Nation and acknowledge the long history of all First Nations in Ontario, and more recently, the Métis and Inuit peoples. I say this in the spirit of reconciliation and importance of reminding all of us that we share this land with one another, and first and foremost, the Indigenous peoples. It is wonderful to have so many people joining us today. We heard that 300 had signed up for the webcast, and I want to give a shout out to former bencher Bob Evans, who doesn't need to learn, but he continues to participate, and he's on webcast. To us, this is an indication of the importance of initiatives like Access to Justice Week to advance conversations about issues at the forefront of justice. This week is organized by TAG, the Action Group on Access to Justice, in partnership with over a dozen organizations. It's jointly funded by the Law Foundation of Ontario and the Law Society. TAG works with a range of justice stakeholders to develop meaningful, public-centered solutions that advance, hopefully, systemic change. Today and throughout Access to Justice Week, we are gathered to talk about ongoing access to justice issues. This week is a call for more coordinated and collaborative action to address a growing access to justice need. Together, we hope to advance systemic change. Facilitating access to justice in Ontario is part of the Law Society's statutory obligation. This is an obligation that matters. This is an obligation we should not take lightly. Attaining our common goal of an accessible, fair, and effective justice system for Ontarians requires genuine and respectful collaboration. The Law Society is committed to collaboration with all of our justice sector partners to advance the rule of law and access to justice for the people of Ontario. Lawyers and paralegals have a critical role in facilitating access to justice. Lawyers and paralegals throughout the province provide legal advice to people so that they know their options when they have a legal issue. Many lawyers and paralegals in private practice are helping those with limited means by offering reduced rates or by offering services on a limited scope basis. The Law Society and the lawyers and paralegals we regulate cannot solve the access to justice challenges alone. That's why we work with First Nation governments, provincial and federal governments, the courts, Legal Aid Ontario, and other licensees in advocating for changes and improvements in how legal services are delivered in Ontario. Committed to increasing competency, the Law Society facilitates discussions such as the one to follow, to improve licensees' knowledge and understanding of various matters. These learnings directly impact their abilities to serve Ontario's diverse communities. This morning's panel is about the justice journey of Indigenous peoples, highlighting an Indigenous viewpoint on the concept of innovation and provide recommendations to further improve how Indigenous perspectives are reflected in the Canadian justice system. I look forward to hearing the perspectives of today's esteemed panelists. I would now like to introduce these esteemed panelists. Don't worry, it's not a roast. I know them all, and I've just met Justice Abonswin. But before we get to that, it is a well-known fact that Indigenous people are the most overrepresented community in Canada's criminal justice system. We could say the same about the child welfare system. If you had any illusions, consider these stats. Indigenous offenders made up 30% of all admissions to federal custody in 2017 and 2018, compared to 22.5% 10 years earlier. And if you recall, the Truth and Reconciliation Commission said that we are overrepresented in the criminal justice system and the child welfare system at rates higher than the residential school era. It is not getting better, people. Indigenous women now make up more than 40% of the female population in prison. Indigenous communities make up roughly 4.3% of the population. Since the mid-1990s, the federal government has been looking into reviewing sentencing procedures in the criminal code, especially with regard to Indigenous offenders. How far have they gotten? And are any of these measures working? Today, we will explore the justice journey of Indigenous peoples, highlighting an Indigenous viewpoint on a concept of innovation and exploring recommendations to further include Indigenous legal orders, laws, and values within the Canadian justice system. Without further ado, I'd like to introduce today's panel. Madam Justice Michelle Abonswin is fluently bilingual in French and English. Not sure about her Indigenous language. She's probably working on that. She is an Abenaki of the Odanak Band and the first Indigenous judge named to the Ontario Superior Court of Justice in Ottawa. Prior to joining the Superior Court of Justice, she was general counsel at the Royal Ottawa Healthcare Group and previously counsel at Canada Post Corporation. Madam Justice Abonswin practiced in the areas of mental health, labor, employment, human rights, and privacy law. She has also taught part-time at the University of Ottawa's French Common Law program. Madam Justice Abonswin is a frequent guest speaker on issues of mental health law, Gladue principles, etc. She recently, in her spare time, received her LLM Health at Osgoode Hall in 2014 and is currently a PhD candidate at the University of Ottawa, where she received her LLB from the French Common Law program. Madam Justice Abonswin was awarded the Rising Star Award by L'Expert magazine, recognizing her as one of Canada's leading lawyers under 40. In May 2019, she was inducted into the University of Ottawa's Common Law Honor Society. Dr. Delia Opikapiu received an honorary LLD from the Law Society of Ontario on September 25th, 2019. I was very happy to have been able to ask the Treasurer to bestow that recognition on Dr. Opikapiu. And this was done at its call to the bar ceremony in recognition of her advocacy work in furthering the cause of justice for Indigenous peoples and human rights for all Canadians. A member of the Canoe Lake Cree Nation in Saskatchewan, Ms. Opikapiu was the first Indigenous woman to be called to the bars of Ontario in 1979 and Saskatchewan in 1983. Early in her legal career, she pressed for recognition of the survivors of residential schools, one of which she attended for several years. She was also the first woman to run for the leadership of the Assembly of First Nations. And if you don't know who the AFN is, it's our group of all of the First Nations in Canada. She was appointed from 2008 to 2017 as a Deputy Chief Adjudicator on the Independent Assessment Process, Indian Residential School Settlement Agreement. Prior to that, she was an adjudicator on the IAP, I think they called it URSA, and was also an adjudicator under the Indian Residential Schools adjudication process created by the Government of Canada from 2004 to 2009. Since 1990, she has practiced as a sole practitioner specializing in Indian treaty rights and Aboriginal law, widely recognized by her peers and fans as a passionate advocate and trailblazer. Ms. PQQ has received many awards. Another doctor. Dr. Beverly Jacobs lives and practices law at her home community of Six Nations of the Grand River Territory in southern Ontario. She is also an assistant professor at the Faculty of Law, University of Windsor. An attorney, she became president of the Native Women's Association of Canada, serving from 2004 to 2009. For the past 2 decades, much of Beverly's work has focused on anti-violence work and restoring Indigenous traditions, values, beliefs, laws, and legal orders. She is best known for her work in advocating for the families of missing and murdered Indigenous women and girls, and public education about the history and impacts of colonization. She's been an advocate for changes to policing and the justice system to better serve Indigenous peoples for her whole life. Earlier this year, Beverly was invested into the Order of Canada by the Governor General. She has received a number of recognitions for her work for the missing and murdered women and advancing Indigenous women's rights, including the Governor General's Award in 2008, the Franco-German Prize for Human Rights, and the Rule of Law from the Government of France and Germany in 2016. Thank you all for joining us today. So to start us off, I have several questions for individual panel members related to the high incarceration rate for Indigenous peoples, systemic discrimination, and the missing and murdered Indigenous women and girls report, to name a few. We will then open the panel or the floor for questions from the audience and the people online. So let us begin. Justice Abonswin, can you start us off by speaking about the need for GLADU principles and what GLADU principles are, how they work, and how they might be applied in other contexts, and the benefit of knowing about a person's background. And the person's background has become, I just read in the press this weekend, former Attorney General Jody Wilson-Raybould being a First Nations person. The court had held that she didn't get all the background right of a First Nation person that was extradited to the United States. So maybe to start with, how important getting the background right is. We assume just because we're Indigenous that we're culturally competent, but that's not always the case. And just because I'm Indigenous doesn't mean that I'm culturally competent in other cultures as well. So I wouldn't mind if you could, I know it's a long ask, but I'm sure you can put it all together for us.
Donc, bonjour, hello, Willini. Thank you very much for inviting me to be amongst you today. I'm going to start off with a bit of background because you see the rolling slides. I did add the statistics in there. So we count for approximately 1.6 million Canadians, the Indigenous population. However, we're over 1/4 of the incarcerated population rate in the criminal justice system, which is of course, unacceptably high rate. The issue, I'll start with 1989, the inquest of Donald Marshall Jr. had looked into his improper conviction with regards to a murder. At the time, he was 17 years old, and he was charged with murdering a 17-year-old black male in Sydney, Nova Scotia. And the inquest looked into the police investigation and also into the criminal justice system as a whole, and found that there one, unacceptable high rates of incarceration, but most importantly, the discrimination faced by Indigenous people in the system. And they made a long series of recommendations, and one of them, when I was reading the report, because I am actually writing my thesis on GLADU principles and how they apply, when I was reading the report, I think it's on page 3, the commissioner actually wrote that the population in that area thought that the lives of Indians were less valuable than those of the whites. So it just gives you a flavor of the issues, and this is in 1989 when the inquest took place, and led to, amongst other requests from the different population of Indigenous human rights advocates, to have changes to the criminal code in 1995 and 96 when they made amendments to Section 718(2)E of the criminal code that now made us as sentencing judges responsible for looking at two important issues. First, the unique systemic or background factors of the Indigenous accused before us, and two, also what are the appropriate sentences to put in place now that we're aware of that information. So the Supreme Court of Canada in 1999 was the first time that it looked at this issue. Ms. Cindy GLADU had been charged with murdering her spouse. At that time, she was 19 years old when the index offense occurred. She had a mother of 2 children. She was pregnant. She had gone back to school, had been in rehab very successfully, had strong support family mechanism, and she had a hypothyroid issue that led her to overreact in certain situations. And in this case, her spouse had told her that he had been having an affair with her sister that led her to stab him in the heart. And then afterwards, she pled guilty to manslaughter and received a 3-year sentence, which was appealed all the way up to the Supreme Court of Canada, which did go through the history of the Indigenous population and the sores related to colonization, residential schools, etc., and the impact that it's had on our population, and then reinforce what we now call the GLADU principles, which are really the 2 sections that I've just spoken about under 718(2)E of the criminal code. So we're hopeful after 1999 that we're going to see a change in numbers in the over-incarceration rate, but unfortunately we didn't. And in 2012, the Supreme Court of Canada revisited this issue again in the Ipeely decision, in which they looked at a couple of issues. They did determine that the sentencing provisions of the criminal code could also apply in these situations of Mr. Ipeely and GLADU, where they were on long-term supervision orders, so it was also applicable to that. Also to the fact that an Indigenous person did not have to prove the connection between his or her background, history, and the index offense. And also to the fact that that this applied no matter what the charge was, so from the minor offenses to the serious offenses without any exception. Unfortunately, we're still having significant issues. So how does this apply to our system as we are today? But myself as a sentencing judge, I think everyone has a role to play. Myself as an Indigenous person, but also as a sentencing judge. When I look at the community, I expect that everyone has a role to play. So the lawyers who are identifying their Indigenous clients, social work that's involved, Corrections Canada, MCSCS, which is the provincial correctional system, everyone has a role to play. And it's not just up to one individual. How does that information come to us? Well, it comes to us in a couple of different ways, either in a pre-sentence report that we would receive that's drafted by a parole officer, or either by a GLADU writer. The issue with GLADU writers is they're not all properly trained. So sometimes we'll get, as sentencing judges, a letter. Sometimes it's a full report. Sometimes it's cookie cutter and just talks about the general basics that don't go to the background of that individual. And at times, they're excellent reports, so we do get a cross scan of them. well, how can we use these outside of just the pure sentencing? Well, the Supreme Court says that they do also apply to long-term supervision orders. Our Court of Appeal has also said that they also apply to bail hearings, parole sentencing, parole provisions, in the review board context that deals with our unfit and not criminally responsible accused that are in the system. It also applies to different contempt proceedings in the civil and criminal context. So in addition, we use it a lot, and I'm a fan of this, of getting the background information of the individuals that are in front of us, even in family matters. Because how are we going to work to improve the lives of our people? It's by getting the appropriate information in order to be able to work with the communities at large and the criminal system to properly reintegrate our people within the communities and giving them the proper services that they need. In the family context, also to help the assist in the system, the CAS system that we have in Ontario, and that's why I'm saying everyone has a role to play in family and criminal matters across the board. More recently, the Vien Commission in Quebec Justice Vien issued his report on September 30th of this year, and it's the first one that's dealt specifically with GLADU reports. And I'll just read the recommendations, the calls for action. So they're from 51 to 55. So 51 is set aside a budget envelope earmarked exclusively for the writing of GLADU reports and increase the remuneration for all writers. Call for action number 52, increase the number of writers authorized to produce GLADU reports. Call for action number 53, fund the organizations involved in producing GLADU reports so that they can enhance and standardize the training provided to accredited writers in cooperation with Indigenous authorities. Call for action number 54, periodically review the quality of work done by GLADU report writers in cooperation with Indigenous authorities. And the last, call for action number 55, provide the GLADU letters to be written automatically whenever an Indigenous person enters the system and provide funding thereof. So I guess just a gentle reminder, we all have a role to play when it comes to GLADU principles, and I hope that everyone is mindful of that.
Thank you, Justice Bonswin. I want to, if you could pull up the slide for guidelines for Aboriginal residential school claims. I don't know who's controlling the deck, or is it random? There we are. Now, just so people know, one of the motivating factors for the Law Society of Ontario to develop these guidelines was actually Dr. Bev Jacobs. She was at an Indigenous Bar Association meeting, and she was very concerned about the conduct of lawyers in dealing with residential school survivors. And so this motivated us in Ontario, and we were the only ones to develop guidelines for residential school complainants. This guideline is now being addressed by the Indigenous Advisory Group to see how it might be adapted to future circumstances, whether that be day schools or day scholars, other such possibilities are being considered. And Delia also, Dr. Delia Opiku participated in a Keshen review panel at the Law Society where we looked at the residential school claims. And one of the things that I wanted to ask you, Delia, is you conducted hearings on Indian residential schools. What have we learned from that, and do you have any insights on a go-forward basis how we might take what we learned from the residential school agreement in your work?
What we learned from that is how vulnerable the claimants were with respect to participating at the hearings, and also with respect to their relationship with their lawyers. Justice Winkler, who did when the settlement agreement was being considered by the courts as to whether they would accept it, foresaw that this could be a problem. And he required that in the implementation order that the claimants were unlikely to use the court system to have their lawyers' accounts taxed, and provided a ruling that the adjudicators were to review the legal arrangements made between the claimants and their lawyers. And this became a huge issue within the context of our work as adjudicators. And because I'm bound by the confidentiality agreement that I signed, what I pulled up is some of the public documents that have come out with some of the issues, the problems that came up. And one of the most recent public decisions was made with respect to how thousands of resident school survivors can sue a lawyer who re-victimized them. This particular lawyer, it's been publicized, it's been, so that's something that I'm talking about out of turn. David Blood out of Alberta established offices essentially to deal with Indian residential schools on the blood reserves. But I had hearings with some of his junior lawyers, and there was also an office in Hobbema in Alberta. And he made about $21 million. And the findings, there was 2 investigations by the Law Society. He's no longer a lawyer due to his misconduct. And he was fined that he had re-victimized his clients, that he lacked an understanding of what it means to be a lawyer. So there's about 5,600 former resident school students who can now seek damages against him. And the reason why, I gather he was a commercial lawyer in Calgary and had no experience whatsoever in this area, but he saw the money, future income in this, because the settlement agreement, which was entered into as a result of the Indian residential school class action suits, allowed Canada, or were not allowed, but provided that Canada would pay 15% of the legal fees. That meant that it was that if the case was won, the lawyer would get 15%. It was almost like a sure thing. In the contingency fee agreement that they arranged with their clients, they could also apply up to 30%. Like 15% from Canada would come from Canada, and then they could apply for further 15% for a total of 30%. And there was a lot of money involved. When I left, I was involved for about 14 years, and I left in 2017. We had already made settlements in the amount of $3 billion, not million, $3 billion. And so what I saw was that there was a real push for lawyers to take these cases because of the fact that Canada would pay 15% and a cap, which was allowed by the courts. The applications for the deadlines for the independent assessment process is now closed. You cannot apply anymore. But there's been 2 other settlements, class action lawsuits, and one of them is to do with the day schools. In the day schools, they don't have the same provision. The firm that took the class action lawsuit will provide free legal advice to the claimants. But of course, the claimants can still retain a lawyer if they want, but you would have to pay out of their pocket. So for that reason, the guidelines that were provided by the Law Society of Ontario still stand, because this is a new area. The class action lawsuit is now at the stage, as of August 19th of this year, that potential claimants can opt out, and they have 3 months, I believe, to opt out. And if a certain figure is reached, it's the regular process with all class action lawsuit. The agreement will be terminated if a certain percentage opt out. I suspect that's not going to be reached. So the applications will start coming in probably in December, and they have 2 years to apply. And some of the numbers for the future claims can be high, and so there are instances where I suspect individuals will seek legal advice, even though they have the option of the free advice. And so the contingency fee agreements become very important for that reason, because the awards that they can make, especially for the higher levels, where there's repeated sexual incidents of the amount that can be given on those is fairly high. I think it's about $250,000. It's lower than what you can the courts have awarded for other claimants for ordinary cases, but this is a class action lawsuit that was settled. And so it's important to, I know that the guidelines provide that on the first page that they provide guidance of a general nature which lawyers acting on behalf of individual defendants will find useful in their representation. This was one of the unusual situations where lawyers' fees were going to be covered by the government, and that's why these cases were so popular with lawyers. And so many things happened that were not correct as far as I'm concerned. I find that the contingency fee agreements are the problem. Here they were heavily regulated because the Justice Winkler's decision applied, and so the adjudicators were able to review for reasonableness the contingency fee agreements. In other areas, they're not regulated. A plaintiff can apply to have their contingency fee agreement taxed, but normally First Nations don't do that. And one of the areas that I'm practicing now is in land claims. I'm starting to see that is happening because some of the like the government provides loans for First Nation to pursue land claims if their proposal for that land claim is accepted, but it's quite low. So certain banks and insurance companies are now started to provide alternative funding. And again, there's issues coming up where some of those insurance companies may not be covered by the Superintendent of Financial Institutions, which is a federal government agency that regulates and supervises insurance companies and banks. And so it's really important if a First Nation is going to enter into these arrangements that they ensure that the insurance company that is going to guarantee the loan, because the arrangement will be that the First Nation can pay premiums. And so if they win their claim, they are required to pay back but if they don't win, they're insured, and so a First Nation doesn't have to pay anything out of pocket, except for the premiers. So it'll be very important when entering into this arrangement for that First Nations and lawyers who will be the subject of the legal fees and disbursements that will be covered by the loans from the banks, ensure that the insurance company is covered by the OSFI, the Independent Federal Government Agency. My understanding from what I've heard on the ground is that there's been instances where normally lawyers will ask for 30% of the, or maybe a different percentage of the settlement. But because of these loans, they're in some cases, well, in all cases, they will be paid for their fees and their disbursements on an ongoing basis. And the problem will be that the First Nation should be ensured that they're not paying for both. Either you get a bonus or a percentage at the end, or your fees are covered throughout the process. And it should not be done like they should not. Lawyers should not be asking for both. It's an area that I suspect that these guidelines will become important because there will be actions, I'm sure, in the future because of the amount of money that can, in some of these settlements. Some of these settlements are quite huge. They're in the hundreds of millions. And so it's very important for the Law Society to ensure that these CFAs are regulated well. Is there another part of the question that you want me to expand on?
I think we could come back to it.
Pardon me?
We can come back to
Okay.
it on your visions for the
Thank you.
future.
Yeah.
Now, I think what we're hearing from the panelists is that reports are important. And I know that even at the Law Society of Ontario, when we talk about access to justice and partnering with other strategic groups, we partnered with the Indigenous Bar Association and the Advocate Society in developing a guide for lawyers working with Indigenous people. And it had some of that, the comments about Gladue, about what you need to know about residential schools. And recently it was quoted from a court decision. I think we intended it only to apply to lawyers and paralegals and just to be a start of a discussion for the learning that needs to take place to deal with these very vulnerable clients that Delia is talking about. So speaking about these vulnerable clients, Professor Jacobs has been a legal warrior for Indigenous women and girls. Professor Jacobs, can you discuss some of your involvement with Missing and Murdered Indigenous Women and Girls report and some of your forward thinking about what might happen in the next stage?
Okay. Sure. First, I want to just acknowledge the territory and introduce myself according to who I am in my language. Scano Sokwego, Giaso Gowenkyuse, Ganyankihaga Nyagwai Shautda, Hodinashoni. So what I told you was greetings of peace to all of you. I told you my real name, my Mohawk Bear Clan name, which is Gowenkyuse, and it means she's visiting. So I'm part of a bigger, the Mohawk Nation is part of a bigger Haudenosaunee Confederacy. And I've been raised in my community with those teachings and practicing Haudenosaunee legal orders all of my life since I was born. And I carry that with me with everything that I do, all those principles, and understanding of where I situate myself within that and everything that I do, whether it's personally or professionally. So with respect to the Missing and Murdered Indigenous Women and Girls Inquiry Report, just to, I guess, to clarify, my involvement with the inquiry was basically before in making recommendations to the Minister, Carolyn Bennett, on the what the framework of the inquiry should be. And ensuring, because I have been working with families of missing and murdered Indigenous women for many years before that, and working with Amnesty International and the Native Women's Association of Canada and many other organizations and connections with many other advocates and activists. There was a lot of understandably my own worry about the families of missing and murdered Indigenous women, because there was already some things that were happening that the families weren't being heard. I mean, that was the basis of the inquiry. That was the basis of the advocacy work, because a lot of the families had been doing the work on the ground, sending out posters, putting up posters, doing the traveling to find their missing loved one, attending murder trials where they'd never heard the details of their loved one's murder. And being the first time at that time hearing the ugly, gory, traumatizing details of their murders. And so that became my focus amongst many other things at NWAC. But with the families, there was a lot of trauma. There was a lot of that emotional, spiritual connections in talking about such a horrific, like many other survivors and victims of violence, is such an emotional experience. And so part of being able to understand also where they come from is that my family became a family as well. And so in going through that process and understanding, even before my own family having to deal with it, is trying to work within a system that has no idea. Trying to work within a system that has no experience in identifying the real, on-the-ground, emotional, spiritual. Those are the words that are coming, because many of the families had experienced such systemic issues right from the get-go, whether it was from policing, in the fact that they were not listening to them, with the media, with the fact that they were reporting stereotypes and racist responses, or not reporting at all. Or there was a non-Indigenous woman who would go missing and she's splashed across the media, front page, and then an Indigenous woman who went missing the same time is given maybe a little bit of attention or not at all. So those are some, and then having also to deal within the court system and victim services who are supposed to be helping families and they weren't. I attended the Picton trial in Vancouver, and that was probably the most horrific, disgusting responses to families when they were dealing with, on a mass scale, of violence against Indigenous women and the families having to go through a system where there's no idea and there's no understanding of their needs. And so having to advocate for them was a lot of work. And it came to, in coming to the inquiry and being an advocate for the inquiry itself as the president of the Native Women's Association of Canada. And then the inquiry, having the opportunity to have and make recommendations to the minister. And one of those was culturally based. And culturally based and culturally safe. So that when our people are going through the system, that there's mechanisms in place in order for our people to feel safe, or the survivors, for the families to feel safe going through that system, and the inquiry itself. And so I'm not sure, and I have been very critical of the inquiry in that it didn't do that, and that the negative attention that was there, because I was also advocating for the families at Six Nations directly. And so we had asked for the inquiry actually to come to First Nations communities, and they didn't. We had asked them to come to Six Nations because there are many Haudenosaunee families who are missing or murdered. They didn't. And there was also a meeting that was coordinated with Commissioner Buller during the inquiry that was not part of the report, and asking and making recommendations. And I'm sorry to say, and supporting the families at Six Nations, that they ended up not participating because they didn't feel safe, because they didn't feel that anything was built for them to be able to participate in that way. And so it was a really heartbreaking process to watch what was happening in advocating for it, and then the way that it had ended up going through the way that it did. And the other issue was also about being trauma-informed. Sorry, I wrote my notes on my phone. The other was the issue of being trauma-informed. So being trauma-informed, and I believe this is also something the Law Society is looking at for survivors and the guidelines to in representing victims of violence. So to be trauma-informed, what does that mean? So that means that survivors of violence and victims aren't re-traumatized when they go through the system, or when they go through, whether it's the criminal legal system, whether it was through this inquiry, was understanding. Everyone in the system needs to understand what trauma-informed means. So that means that if I'm traumatized, then I'm not going to be re-traumatized going through the process. And this was also, I found during the residential school, the Truth and Reconciliation Commission. I was also involved in representing clients through the IAP process, is ensuring that they're not re-traumatized, but many did. No matter how hard we tried to ensure and advise about having to tell their story in detail over again, over and over again. So it's not just once, it's many times. And when you have to go through that process so many times, it's emotionally, physically, spiritually, and physically traumatizing, no matter how hard. So what are the resources that need to be provided in order for survivors to go through that? So one of the recommendations was that they have their own elders, their own support people, not from the outside, not put on them, not forced on them, but someone who that they feel comfortable, who they might have gone through the whole process with even before, whoever their support person was, to be able to talk about such a horrific details and emotional details. And so how do you ensure that that no one commits suicide? How do you ensure that that their well-being, their total well-being is taken care of? That's really difficult to do. It's really difficult to ensure and to be an advocate for those who are going through that system. But like I said, to have the process set in place and to ensure that wasn't done. They did have a national families committee at the inquiry, but also there was a lot of unhealthiness that occurred as well amongst families. There was also things that had happened where there was a division amongst families. So the system, the inquiry itself, I believe, really assisted in that division and didn't help to make it better. And so, you know, when the inquiry did come out, the report, I did have the opportunity to represent 2 organizations at the inquiry, and anti-violence organizations, and writing reports for them in their final submissions. And we had an organization that I represented, which was the Ganonkwasra, the Family Assault Center at Six Nations. And we have a really powerful executive director there. Her name is Sandy Montour. And she had a really powerful presentation at one of the hearings at the inquiry. And because she has been so directly involved also not only with family violence survivors, but also with the families of missing and murdered at Six Nations. So she knew the issues, she knew what needed to be presented, and I was really proud of her to really ground and bring the issues forward to the commissioners. So she ended up having a huge quote that was based on looking at the real issues for the families, and that they had to really look at the at that traumatizing and emotional well-being. And so they also had a really powerful it was like a little play that they did at the final submission. So you know how usually in final submissions and the lawyers are standing up to make their presentation for final submissions, and this one I supported the organization to actually present a play. We submitted a written documentation for their final submissions, but the actual presentation at the hearing was done by the organization, and really powerful messages that came on that kind of level. And so it was, I thought that was really important, so that the voices of the grassroots are heard. It doesn't necessarily have to be, it didn't have to be my voice as their lawyer. It was the voice, and which is what I have always advocated for, was the voices of those who weren't always heard. And so that's what I had really enforced. So those words, trauma-informed and culturally safe, were my words. But I felt that they weren't being the resources and everything that needed to be done to ensure that those principles were being followed wasn't done as they should have been, which caused all of the negative attention in the report. But I know that in being critical, there's a purpose in being critical. The purpose in being critical is to bring attention to the issues that need to be addressed and to ensure that the safety of the survivors were a priority. And that has always been my advocacy. And I think being a Bear Clan is a big part of that. And I've said that recently because being a bear and protecting family is important. And that's always been part of my advocacy, is to protect those survivors, those who don't have a voice or feel they don't have a voice. But what I can say is now is that those families do have a voice. There, you know, in originally with Amnesty International, there was about 20 families who had participated who never said a word before. But I believe most of those became part of the family, the National Family Committee with the inquiry, so that their voices were heard there. They were heard, and I can see how much they have grown from the time that I had first met with them to today, where they're now, one is a member of parliament, one is counselor in her reserve. One is a chief counselor. So there's so much of that healing that had occurred over from that time. So that was 2002, 2004 when I first met with them. And with the report that came out from Amnesty was in 2004. And with this inquiry, Missing and Murdered, in 2019. It has been the attention that I was wanting from day one, and the attention that was required for all of Canada, for all of the world to understand this issue. And I had made this point when I first starting on this issue of missing and murdered, and standing in front of the cameras, that there was maybe one camera, and it was APTN in the parliamentary news on Parliament. And from that time, and then seeing the cameras at the Missing and Murdered Indigenous Women's Inquiry and the attention that it did play, that was really important, and really important for the families to be heard. There are still families who didn't get heard. There's still a lot of work to be done. There's missing and murdered Indigenous women that are going missing and found murdered on a daily basis. It continues. It hasn't stopped. And our work as advocates, I want to acknowledge Audrey Huntley, who also has done a lot of work to ensure that the families and this issue is also presented on a national basis. And that it's really important to understand that this issue has not ended, and that despite the inquiry and its recommendations and the attention that it said that this is genocide, that is the issue. And the issue is also about land, and that it is about land and about Indigenous women's relationship to land, and that Indigenous women's relationship to the land has been impacted so much so where our lives are being taken as a result. And so there is a direct connection between the violence of our mother, the earth, and the violence of our women. So that's really, that's the basis, that's like the root of the problem with all of the issues that we're having to address. So thank you.
Thank you. Could you move to the slide, reasons for over-incarceration? Now, as I said earlier, it's not just incarceration, but we're also overrepresented in the child welfare system. And if you look at some of the comments about why, the whys, I can tell you, and I agree with Bev, it may simply just be that we look Indigenous. It's not necessarily poverty. I remember my son, and I'm affluent, I'm a lawyer, and economically I do well. And my son came out crying and he said, "Mom, why are they murdering Indigenous women and girls?" And I said, it could be just because they're Indigenous women and girls. Doesn't have to be that they're poor. I grew up with it too. I saw it when I was growing up. And so people just jump to poverty. And it's true, they are more targeted in those situations. They're more vulnerable. But, on a positive note, because I'm asked to ask if there are some positive research or innovations that are happening in our legal community to address this over-incarceration or over-representation of Indigenous people in the child welfare system. I can say that my firm works with the Assembly of First Nations on the Child and Caring Society case, where the Human Rights Tribunal found that residential school is not over. It's very much a legacy that impacts Indigenous peoples even today. So that's a positive result. I was recently involved in a case where we brought Anishinaabe law to the court for the first time with the support of our elders, women, children, and we went, like you said, we brought some of the court to our Indigenous communities. We said it has to be this way, especially when we're talking about Anishinaabe law. We need to be talking about that in our communities, on our land, because we're connected to that land. And so those things happened in 2019, 2017, 2018. Way more needs to be done. And I'd like to ask each of the speakers if they see some successful innovations and research. And I'll start with Delia, and I'll come down this way towards Bev. Any successful research or innovations that you think is happening in our legal system?
Well, there's 2 points I want to make on innovations. The first one, the case that you talked about, Reclet, is it? This Robinson-Huron Treaty case?
Yeah.
Yeah.
Restool.
Pardon me?
Restool.
Yeah, it's very important. My understanding is it's the first time that they used the Federal Court of Canada rules on oral interpretation and how to deal properly with First Nations.
Elders.
Yeah, and the Indigenous Bar Association was also involved in that. I was so impressed with that case. It's the best case I've heard of how the judge understood the Anishinaabe law and how she treated the plaintiffs, the people that were involved in the case, and her understanding of the law and her participation in the ceremonies and the smudge ceremonies. I understand you were one of the lawyers there. That was an incredible case. Like in other areas of my work, I'm recommending people who to read it because of how the respect that Judge Hennessy had for and how she took the time and the patience to truly understand the people. And the innovative things that you did, for instance, I'm particularly interested because of my interest in treaties and land claims, that you used a linguist for the first time to interpret the treaty so that she translated to the language, the Indian language, and compared, or someone compared the differences in the words so that in some cases there was not a meeting of the minds. And that goes across the board with respect with treaty rights. So that was innovative. The second point I want to make, I haven't seen any research, and perhaps someone should do that. With respect to residential schools, I had hearings right across the country, from the territories to the British Columbia to Nova Scotia and every province. And I went to Indian residential school for 11 years myself, and I've worked in this area with on First Nations and Indigenous people issues, and I've been admitted to the bar for 40 years. I didn't realize how shocking the impact of the Indian residential schools were until I conducted those hearings. The actions that were perpetrated against these people, my fellow students, and which resulted in so much harm and damage to their lives, which in fact contributed to the damage that is passed on from one generation to another. One bright light I saw was the grandparents who, in many cases, were starting to heal and become well, and were making an extraordinary effort to deal with the issues in their family, particularly with their grandchildren. I found that very hopeful for the future. In many cases, their own children were so damaged, but they were now putting their faith and hope on their grandchildren. And I can't write on it, like I can't really deal with it, because I am, if I gave personal examples, I suspect I'd be breaching my confidentiality agreement with the work that I did. But that was one area that really gave me a lot of hope.
So I'll talk about some of the research. Two professors from the University of Ottawa, Sylvestre and Boileau, have done a lot of research with regard to the over-incarceration rates, and they issued a lengthy article, I think in 2018, with regard to their stats across Canada, which was, the numbers are shocking, about how many percentages of times are trial judges actually taking into consideration Gladue principles, etc. I've done my own research with regard to the use of Gladue principles in the review board context for our not criminally responsible and unfit accused. So those are, that there is research that exists, and Professor Sylvestre actually was retained by the First Nation Association in Quebec and Labrador to do an extensive report on Indigenous issues, and I understand that that will be released shortly. So there is research being done. It's not always the positive outlook, but at least it's informing, because I think what's important, and I think you've talked about that also, Diane, is the importance of having knowledge and sharing that knowledge with others of what's out there and how can we improve and get better. There are a couple of other things. We have now 2 Gladue courts in Ontario, one in Toronto that's been more long existing, and I'll refer you all to a decision from one of my colleagues who, because these are Ontario Court of Justice courts, who's now one of my colleagues in Superior Court in Toronto, Justice Sean Nakarutsu. He wrote a decision called Armitage, which I remember I was general counsel at the Royal when I read it, and I was so touched I actually sent him a personal letter where he compares Mr. Armitage to a tree. And it's almost poetic. It's quite amazing. I really recommend that you read that decision, because you really can see how the perfect application of Gladue principles by a judge in a matter. And we've also, in our provincial court in Ottawa, opened a Gladue court a couple of years ago. And one of my colleagues from law school, Elder Claudette Commanda, actually gifted feathers to our courthouse So when I was sworn in May 2017, I was quite fortunate. I was sworn in on an eagle feather. And so we do have that capacity now in Ottawa to swear people in. And I think that that's very helpful and soothing for the people that actually appear in front of us. It's a step in the right direction.
I'm not sure I can answer the question because I don't think that there has been anything. In fact, I think it's worse. I just finished writing as an academic, writing a paper on decolonizing corrections. And basically the conclusion is the abolishment of the jail system for Indigenous women specifically. And the reason why I say that is I looked at all of the research that's been done, all of the studies that have been done, all of the justice inquiries, all the justice commissions since 1989. And my Mohawk sister, my late Mohawk sister, Patricia Montour, who has been already studying and making the comments that the system is already a wreck, that it's actually worse at that time in 1990 when she wrote that and participating in the Creating Choices report, participating in the task force, the Arbor Commission's report, the Royal Commission, the TRC, Missing and Murdered Inquiry, right? All of these statistics, they're provided here. They're actually worse. They're worse today than ever. They're not getting any better. So why is that? I mean, and I respect that there has been, Gladue courts, and there's been, minimal changes in the courts. But also in order to achieve those minimal processes is that you have to plead guilty, or you have to be guilty, right? You have to go through a sentencing, so you're already guilty, and to go through those processes. So with all of these things that are happening and the changes, it's not getting any better. But one of the successes, I guess, that I can say is that Indigenous legal orders, Indigenous laws are starting to be respected. They're starting to be respected in the system because we have judges, also Indigenous judges, but also judges who understand. So there must have been a reason. There was probably some kind of training. There was probably something that was done in order for judges to be able to understand, and I think that needs to continue. If we are to bring Indigenous legal orders into the court system, I actually wouldn't want to bring it in if nobody understood it, if there was disrespect to my law. One of the successes also I can say that is occurring, and maybe the shifts and the changes, is that we have Indigenous legal orders being taught in law school. So I'm now a professor of law, being able to teach Indigenous legal orders as a mandatory course at the University of Windsor. So all of the first year law students are learning about Haudenosaunee law, they're learning Anishinaabe law, and they're learning Cree law from Haudenosaunee, Anishinaabe, and Cree instructors. So that's, I think, is a success, because now students who may become a judge, students who will become lawyers will understand that there is a legal order that was here before Canadian colonial law ever existed, and that they need to understand that from an Indigenous lawyers, from Indigenous elders. So we have knowledge holders and elders who are also coming in to assist in teaching the course. And so I think that, and the reason why is also because of the calls to action in the Truth and Reconciliation Commission, calling on law faculties to implement Indigenous legal orders. And we've also developed an Indigenous Legal Order Institute. So it's also going to be part of our ongoing work to support Indigenous communities to highlight and empower their own Indigenous laws. And so I think that's really important to understand. And I think in the work that I've done with women who have been inside and others who have been in jails, that what has helped them out of that system was understanding their own laws and how they participated in their own ceremonies to heal themselves. So they're now outside of that system. So I think that's a success. The system itself, I believe, is not any better. Sorry. Thank you.
So you were talking about, Bev was talking about Chief Justice Finch, former Chief Justice Finch of the Court of Appeal in British Columbia. He really resonated with judges across the country, non-Indigenous and Indigenous judges, when he talked about the need for reconciliation with Indigenous peoples and that all Canadians in the administration of justice, including judges, had a duty to learn. And I think that, judges have been educated. I participated, I signed a confidentiality agreement, but I did participate in an Ontario Superior Court Justice education for half a day, which was devoted to Indigenous reconciliation, and they continue to do that work across the country. So it is happening. And you mentioned the the Truth and Reconciliation Calls to Action 27 and 28 specifically, which talk about our duty to learn as advocates. And we are looking at that at the Law Society of Ontario. We're also looking at it at the Federation of Law Societies of Canada. And so we'll hear more on that. The other thing that is happening it's not just the duty to learn, like I see that my colleague Linus from the Ristoul case is here. And you also saw a new guideline for federal lawyers on dealing with Aboriginal and treaty rights cases that was very different. Instead of using seed surrender and release and technical defenses, they had to look at how to deal with the cases based on principles of reconciliation. And you'll hear what you didn't hear in the Ristoul case. Based on those guidelines being at play, Canada did not appeal the Ristoul decision where we were applying Aboriginal laws. So we are seeing that this learning that's happening, that's so necessary, is making some impact. Again, I talk about at the Law Society of Ontario, we did the Keshen Review panel, and a lot of what you were talking about, we heard about culturally based, culturally safe, trauma-informed. So we have recommendations that the Law Society of Ontario is now implementing in their discipline and tribunal processes, and they're looking at how they can. I think next month we're looking at changes to the rules on how you deal with vulnerable witnesses that needs to be different. And so those are things that I'm seeing that the Indigenous perspectives are reflected in the Canadian justice system. And I'll say that in the Ristoul case, we said, no offense, Glynis, but we said we could probably win this case just based on the common law. But our elders said, you're not taking our treaty just based on the common law. You have to bring in our Anishinaabe laws, and some of them being so sacred. So at every day of the hearing, there's a sacred fire with the medicines so that those spirits come and our ancestors come back, in ensuring that when we're doing our work on the reconciliation of the common law principles, with the Anishinaabe law principles, that they're there. So I'm seeing some progress. Maybe I'll start with Delia. What do you think needs to change to ensure the Indigenous perspectives are reflected in the Canadian justice system?
I think what needs to be changed is the training of judges, because the Supreme Court makes decisions and not everyone follows it in their decisions. And in that case, Ritul Hennessy wrote the portion on the interpretation of treaties, right? Treaties. I thought that was exceptional, and she really followed what the Supreme Court has been saying. But I'm finding, because I do have some a few land claims that I'm working on, that they're not being properly applied. The innovative decisions that Supreme Court has made, except for Hennessy, who, I'm sure there's other judges, but that was the clear example of her doing that. And what was innovative about it, as you say, is that there was an agreement with her rules of interpretation by, I think, Canada, and didn't appeal. And of course, that helps all kinds of other land claims cases across the board. That was especially helpful. And so I suspect you have that that has been a problem with the Gladue decision also, where the Supreme Court made decisions, but they're not necessarily being followed.
Yes, and Sylvestre and Boileau's research is clear that that's one of the issues, and that's basically what also IPLE tells us is, unfortunately, from Gladue in 99 to 2012, the incarceration rates got worse. And a part of the problem was that in the trial courts, that they're not automatically following the Gladue principles. And I'm a strong advocate, and I think education is the key. Education is the key to make sure you relate the information to the legal community and also the community of the individuals involved and everyone else that touches these matters. So pass the word. It's really important to share this information with others, and every time that you attend a session where you learn something new about Indigenous rights and things of importance, especially in my world of Gladue principles, share them with your colleagues. Because unfortunately, not everyone attends these types of gatherings, so the information is not automatically passed down. And the starting point in our legal community is really through the TRC recommendations with the education at the university level, which is quite exceptional, because when we went to law school, we didn't have anything cool like that. So, yeah.
Yeah, I totally agree. I believe it is about education, public education, whether it's for lawyers, judges, everybody who works within the system. And by the way, I don't call it a justice system, and I wrote that in my paper. It's a Canadian legal system. It's not justice. It's not justice for Indigenous peoples, I believe, yet. It is a very racist system. It's based on colonial principles, which is why we're dealing with systemic discrimination, with systemic issues inside, whether it's policing, whether it's within the courts, whether it's in corrections. Right, so all of those systems need a lot of work, and I believe that everybody who works within those systems need to be educated about who we are as a people. They need to be educated about Indigenous laws. They need to be educated about the real history, about the truth. Everybody needs to read the Truth and Reconciliation Commission report. Everybody needs to read All of those reports, I mean, there's been there's hundreds of reports and inquiries and thousands of recommendations that have been made to make change in the system. They just need to be implemented. And we have a role as lawyers also to ensure their implementation.
So one of the things that was very clear to me when I read the Truth and Reconciliation Commission report, and I say this often, is when they made recommendations to calls to action 27 and 28 and other calls to action that were specific to people in the legal profession, lawyers and paralegals and judges, they said that from their experience and talking to Indigenous people across the country, that people in the legal profession were the least trusted. And so that shows us how important this work is. Your duty to learn. Good thing for us, CPDs were approved by the Supreme Court of Canada, so we're going to continue to ensure that we partake in the necessary education that is happening, specifically in Ontario for us. I'm now going to open for some questions. Someone's going to pass a mic around. And if you have someone specific or generally that you would like to hear from? I thought we were going to ask this group first and then the iPad. Wow. Can we just take some questions in the room? This is too big. They wanted to know more about the Indigenous women. Cue the mic. Someone was trying to cue me earlier. And Bob Evans, I gave a shout out to you. I thought you were going to be online. I saw your name come up. I just mentioned that even though you don't have to, you continue to exercise your duty to learn, and you're always updating yourself on, reconciliation work that needs to be done. So I'm happy to see you here.
I'm sorry I was late because I was looking forward to your introduction. I do appreciate the four of you giving us this wonderful information about the work of the Truth and Reconciliation, and there's the inquiry of missing murdered women that wouldn't have come up in earlier generations in our public life. So it's not perfect, but at least it's a start. And please keep going. Please keep lifting the bars.
Thank you. Are we ready for questions?
Excuse me, just I hear.
Can you introduce yourself and where you're from?
Sorry, my name is Ed Brogdon. I'm a lawyer. I practice in Northwest Territories, Nunavut, and all over Ontario, almost entirely a First Nation practice. You were showing the education so much at the top level. It seems to me that what I'd like to know is that there's work being done elsewhere. My second Eagle Feather was given to me for battling the Children's Aid Society. I went to show that they didn't know enough. We proved that they knew nothing about First Nation. And that means that you're not treating the families right, and that to me is where the incarceration problem probably begins. If you get in meddling in the families, breaking up families artificially. Isn't this a group that should be focused for education on First Nation differences and methods? Thank you.
Over to you, Bev. Say, I agree.
Yes, that's where it has to happen. So that's part of understanding. Actually, when it comes to the differences between Indigenous worldview and laws and Canadian colonial criminal family law, there's a totally different worldviews that needs to be taught everywhere.
I will take one question. Michelle Tiger. She's asking whether there's some books she could read to follow up on what was discussed. And as I indicated, the Indigenous Bar Association, the Advocate Society, and the Law Society of Ontario partnered, and we developed the very first guide for lawyers working with Indigenous people, and it references, everything across the board. So it's a start. Second, we're all talking about the Truth and Reconciliation Commission report, the Royal Commission on Aboriginal Peoples. Those are just some of your starting points if you want to learn more about this.
My name is Judith Schoenwald, President of York Region Paralegal Network. From our name is suggested that we are not lawyers, we are paralegals, and our scope is very limited in the legal profession. Nevertheless, I do feel that we can contribute greatly to this conversation. Have you envisioned anything for us paralegals specifically, how to engage with the Indigenous communities, how to spread the word, basically because our scope of practice is very, very limited. Thank you.
You're looking at me? Well, again, here at the Law Society of Ontario, we regulate both lawyers and paralegals. So when we talk about the education that we're doing, it's not exclusive to lawyers. It is intended for paralegals as well. We do have paralegals that are on our Indigenous Advisory Group sitting up here, and they're very active in giving the Law Society advice on the work that needs to be done to improve these horrible statistics. So more to come.
Can I just add, one of the important things that I always tell people is, if you want to help, go in the community. Don't wait for them to come to you. It's really important to go on site and meet with the elders and the members of the community, because that's where it all happens.
I agree.
I agree with that as well. That was one of the things we did in the Ristoul case, is when we went into ceremony, it was important, our elders said, to include everyone. So the Ontario Crown lawyers, the Canadian Crown lawyers, the judge, and all of the plaintiffs' counsel, we all participated. And I think it was one of my criticisms. I was at a Glad You panel, and I often think that judges will attend events at the Law Society, at the Advocate Society, but they never go into those communities that they adjudicate in. And I think if they did, it would be a much better learning experience to realize who our people truly are. Who's next?
I have the mic. My name is Audrey Huntley. I'm a victim rights paralegal at Aboriginal Legal Services. Thank you all, Miigwech, so much for all your comments.
And you're on our Indigenous Advisory Group?
I am, along with Sheila Warner, also a paralegal. And I really appreciate, actually, that you, Diane, always mentioned paralegals when you said lawyers and paralegals, because we're always, like, piping up and saying, and paralegals. And it was nice to not have to do that. My question is for anybody on the panel, but probably I hope that maybe Bev has done some thinking about this, is that I always encounter quite a tension as an advocate of abolitionism myself when I'm supporting families of missing and murdered Indigenous women, girls, trans and two-spirit people who often in their grief and shock are looking for justice but don't find it in this system. And really all that they can ask for is longer sentences. But I believe that if we want to decolonize and if we want to go back to some Indigenous practices, that restitution should be a really important part of finding justice for people. Do you see any way that this current legal system could incorporate some form of restitution? First, like traditionally when someone murdered a mother or father, then the family, that person had to make up for the roles and duties that family lost, which I would think would be so much more useful to a family than just having the offender go sit in jail.
Yeah, I have been thinking about this because my own family has had to deal with it, and if we're to follow our own laws, what would we do to the young Mohawk man who murdered my cousin? And I don't know, I mean, I think anything can happen in changes that can happen within the criminal legal system. Like a precedent could be set to add some kind of restitution based, I mean, we could have restitution based on Indigenous legal orders. Restitution based on, if I were to talk about Haudenosaunee legal orders, if somebody took a life, that's actually like the worst law that can be broken, especially murdering a woman who's pregnant. Like that's like the worst thing any man could do according to our law. So if we were to go back to the knowledge of our elders and those knowledge holders, because we're impacted, our minds are also colonized, right? Where we want to say, oh, he should be in jail forever, right? He should be serving life because he took a life. But like you said, it doesn't resolve the deep, very deep issue about why. Why did he do that? What happened to him? What happened in his life for him to murder someone? And he ended up winning an appeal. So he's out of jail. So I looked at myself, you know, not only as a lawyer, but as a family member, and thinking, if my family were to address this restitution, it would take a very long time because of that mindset. If we're to return back to our own ways, what would we have done if somebody had murdered a woman who was pregnant? And it's almost like if we were to go back to our own laws, I'm not sure if anybody's ever seen it, but he would be punished. He would be punished, but they would also look back and say, what happened to him? What laws did he miss? What did he miss growing up about being a respectful man? What did he miss about being a caring man? Because those are our laws. What happened? Did something happen to him where he didn't understand about this love, this unconditional love? So it's like going right from the time he was born until the point of the offense of what he did, and having him accept his responsibilities. So, and that it isn't just him, that it has to be his family, his clan, his nation, that also has to understand what happened to him. So it doesn't become just an individual responsibility, it's because we come from that collective. That has to happen. For us as a family, we have to understand as well our own responses, our own healing, our own understanding of why it happened, of why her life and then the next generation's life has been taken. And that's a lot of work. So when we're working within this system that's constant, like it has to move on a minute by minute basis, that our concept of colonial time needs to disappear, because we need time to be able to have that discussion in today's society about how do we reconcile that. So does it mean that then the family, because I believe this is what had occurred, that the family had to then be responsible to the victim's family, and that they're there to help them for the rest of the family's life. That's Is it that kind of restitution that we're looking for according to our own laws? And if we come to that point, what happened in the courts is that everybody's, even in the courtroom, you can see it. Families for the victims, families for the offender, and nobody's talking to each other, right? And in fact, there's so much anger and so much hurt and so much pain going through that process. So delving really deep into that, where you actually end up coming together, the families come together and resolving it on a really healthy, healing basis according to our own laws, because that's what it was about. Our laws was about creating peace, was about that unconditional love. So if we're to return back to that system, it would be totally outside of the way the system is right now.
Good morning. My name is Caitlin Tully, and I am Algonquin from Kitigan-Zibi. And the question I have for the panel is, as a new lawyer who has recently entered the legal profession, I'm wondering what challenges do you see for the next generation of lawyers who can hopefully walk in your footsteps one day?
First of all, congratulations.
Miigwech.
Yes, I knew Caitlin when we were on Parliament Hill and addressing the issues of missing and murdered, so thank you and congratulations. I actually think we're in a really powerful place as Indigenous lawyers, as Indigenous advocates, because there is change happening. And to be part of that change is really important. But I also think about yourself and your self-care and what you're doing to help yourself to maintain your well-being and your identity.
Delia, do you have any?
She wants advice on how to become like us.
Better than us, Delia.
Hard work. Do not be afraid to challenge what you think is wrong, and act on your feelings. If you feel that something is wrong, act on it, and your client's strong feelings about whatever wrong is that you want to fight for.
I'll tell you the two pieces of advice that I got when I started practicing, and I live by those, and I tell anyone who's worked for me in the past this, and even students that I mentor at the university, two things is you only have one reputation, make sure you're guarded, and always act respectful to others, even if you don't get along with opposing counsel and others. And make sure that any case you touch, any file, that you prepare it to the point where you're confident, you're ready to move forward, because preparation is the key to anything moving forward. And the last one that I've always lived by is when someone tells you can't do it, prove them wrong. I've done that. I remember when I was in high school, I had said, well, I'm going to be a lawyer, and they said, oh, you're from a little French town from Northern Ontario. You're not going to get into law. And I said, yeah, watch me. So live and die by your convictions.
Hi, my name is Kathleen Nielsen. I'm a law student at the U of T currently. You talked about kind of all of these recommendations that have been, that have come out in the various reports, the RCAP, the TRC report, that they're all there and that they now just need to be implemented. Do any of you have any thoughts for sort of law students who have not yet qualified? What areas of law or what kind of work we could do where we could be the most effective towards reconciliation, towards working with Indigenous communities?
Bev?
I'm thinking.
I could start.
Yeah, go ahead, Daniel.
For law students, on what kind of area of law you might go into to deal with reconciliation. Any area of law has to deal with reconciliation, particularly if your clients are Indigenous people, any kind of law. But you have to, and for the purposes of the other person that wants to become like us, you do have to look, if you're going into private practice, to ensure that you're in an area of law that you will get paid. It's really, really important. And one of the things that I was advised from the beginning was I'll always have at least one or two institutional clients because they're able to pay. And when I say institutional clients, I mean a First Nation, an organization. In my case, I've worked for corporations, someone who can because you always need that. Otherwise, marry someone who has a regular job, which so at least you can meet your mortgage. Because it is difficult when you're serving Indigenous clients. In many cases, they just can't afford to pay. So you really do have to consider the type of practice you're going into and how to protect yourself so that you can continue in your practice. That's it.
I know for me, I do recommend this. I know it's a niche, but mental health is really important. It does touch our community a lot. Not a lot of people know about it, how it works, how the provincial system works with the Consent and Capacity Board, how our not criminally responsible and fit system works. I think that's a niche area, but it's extremely important. I know a lot of criminal lawyers who are amazing defense counsel know, but there's a lot of work to be done on that side, so I strongly encourage you to get yourself a mentor. That's the thing. When I had started at the Royal, I was a labor, employment, human rights lawyer. I'd never done anything close to criminal, and all of a sudden I become general counsel at the Royal after practicing close to a dozen years, and I didn't know anything about mental health, but I wasn't too proud. I thought, you know what, I need a mentor. And I went and saw someone, Barb Walker-Renshaw, shout out to her, who is an amazing mental health lawyer, who took me under her wing and taught me everything that I needed to know to be successful. So it's not exactly what your question is, but I think it's really important to get yourself a great mentor, which was the previous question. It's really important.
As you know, I teach law students, and one of the first exercises that we have in the Indigenous Legal Orders class is asking where you come from. And so and it's not where you live, it's who are your ancestors? Where do you come from? And because that to me is what helps in reconciliation, because it isn't just Indigenous people who have to reconcile. It's not a one-sided issue. And so what was really powerful was that 170 students stood up, and they talked about where they're from, and they talked about their understanding of their ancestors. And one of the things that I had seen after that exercise was it was like an instant understanding of their relationship to the lands here. There was an instant relationship that they live and are benefiting from living on Indigenous lands and territories. And it was the very first class, and it was really, I think, an eye-opener for many who never thought about it that way, who never thought about how they actually benefited from living on Indigenous people's lands and territories. So, but then there became this issue for them was to, okay, well, what is it about my history that has benefited me? And what is it that I haven't addressed as to what has happened and what my people brought here? So that has become part of the conversation as we're going through. And it's empowering. I think it's empowering in understanding that true relationship of reconciliation.
As a person from U of T Law, I would suggest participate in the courses. You're there to learn. You have a duty to learn. And I know when I was there, we started a poverty law clinic at Council Fire here in Toronto. When I was there, we started a national moot. So I was very active in law school in the reconciliation agenda before that word was even a word. So participate where you can. That's what I would suggest.
Can I just make one more point?
No.
Yeah, along with what the judge said about well-being, in order for you to work well in reconciliation, you do have to consider not only your health, your physical health and all that, but also economically, as I said. And for that reason, ensure if you're going into private practice that your best friends are your banker and your accountant.
Good morning. My name is Marcus Pratt. I'm from Legal Aid Ontario, and thank you very much for this panel discussion. It's been very informative and moving. My question is around GLADU reports and how we expand the GLADU information that's brought to not only courts but other decision makers. It's a program that Legal Aid is involved in. We fund Indigenous organizations to hire GLADU report writers, and I say that with some humility and acknowledgement that we don't nearly do enough. But one of the challenges that we have as we consider how to expand it to other proceedings is that right now the GLADU report model is labor intensive, and to provide quality reports, a lot of work is done by the GLADU report writer to learn about and it's in the criminal context, the accused experience background, to bring that to the court. So it's limited largely to the criminal law context when someone has been convicted and they're facing a serious term of incarceration. So my question is there any work either in the academic field or as a judge on how to kind of bring that same background information to other proceedings, such as at a bail hearing, where it's a much quicker turnaround time, or in child protection matters. In both of those, there isn't, the accused hasn't been convicted, there's a presumption of innocence, or there's a different legal test. And so I'd be interested if there's been any work on that.
I can tell you that I sit across the board. I sit a lot in criminal, but I also sit in family and civil, and as judges, we're all independent. We all have our own views on this, but I'm extremely open to, it doesn't have to be a GLADU report. It could be a letter. It could be oral evidence. It's just to be mindful that it doesn't absolutely have to be this report, and that's what it has to be. And it's to have discussion between counsel and with the judge about how this information could be provided to the court system, because I think that us as judges, we have an obligation to spread the word and to educate, and I've posted my research that I've done on GLADU on our internal intranet, and a lot of times I have colleagues who will come and ask me questions about GLADU reports, so I always tell them just to be mindful and ask the questions, because even as judges, we have an obligation also to ask the questions. It may not be obvious to others, but as being an Indigenous person, when I sit in bails, and this happened recently, I had an Indigenous person in front of me. I flat out asked, because no one had mentioned it. And I asked, do you have Indigenous background? And he gave me some information, and his counsel, I think, was surprised, and I said, counsel, make sure you look into that, because this is information that's important. So I think we have, as judges, an obligation to also ask questions. not always, I think lawyers have a very strong obligation to ask the questions, but on the receiving side, if we don't necessarily see it, I'm always mindful of it.
I can say that, again, if you look at the Keshen Review Panel, we did find that the Law Society has been applying the Gladue principles to some of our lawyers who've gone through our system. We did look at it. I also think that there needs to be more focus in the North, in smaller communities, because I know when we did the review panel, we found that some of the precedents that Law Society of Ontario was focused on were really urban-based, and the approaches to Gladue don't apply similarly when you're living right next to all your families and the victims and everybody in the communities involved. Now I have to do my chair duties. We have 1 minute, but I haven't ignored the people who've been sending messages, and I'm just going to generally answer. Where can you find more on Gladue reports? You can go to the Law Society Guide for Lawyers. We write a section on Gladue. You can go to Ontario Legal Aid, Aboriginal Legal Services. There are a lot of options. There was also a question about, are we going to teach because you made this comment, real history in Canadian. I know that there was work in Ontario with the Liberal government. I'm not sure if they followed through, but at law schools, certainly, we are seeing a trend across the country where they are teaching Indigenous legal orders and Indigenous laws and Indigenous history. There was also a question about, the administrative tribunals and what the Law Society is doing. Yes, look at the Indigenous framework. We're going to be bringing something to convocation on dealing with vulnerable witnesses in our tribunal process. And what was another? There was a question whether Dr. Jacobs could elaborate on the murdered and missing Indigenous women and girls' contribution to family divisions among survivors. I think that will take much more time, and hopefully we'll have another CPD. I thank you all for coming. In my language, Chimigwech, Bamapi. And thank you to our great panelists.